I guess there can be some hidden risks that in an uncontested divorce, but everything has risks, right? I guess the main risk is that you don't know what the judge is going to order if you had gone to trial. That's why whenever we do prove-ups, when there's agreements, you always say, you understand that we're not having a trial here today, and you understand that you could have had a trial, and you're entering into this agreement, and that the judge could have ruled something completely different, maybe the same, but you want this agreement entered because this is your agreement that you have with your spouse. So I think the main risk would be what would have happened if I went to trial or temporary hearing or whatever it might be. Yep, think different.
Yeah, and I also think with an uncontested divorce, you're putting your faith in each other. The spouses are putting faith in each other that they're being truthful about, for example, the financial circumstances. If you have a couple where one spouse has always handled the money and the other spouse has just kind of always just followed, there is a risk that there could be some assets that one spouse may not be aware of, and so they may not be fully divided, or it may not be divided appropriately, those kinds of things. So there is a leap of faith that is required in an uncontested divorce, in the fact that you just have to accept that you're both being truthful and honest and moving forward in the best way possible for their families.
And now one of the things that we always require, and I'm a stickler about, is having inventory and appraisements.
Absolutely.
Inventory appraisements is basically tell me what you own and what you owe. Each party fills out an inventory and appraisement in 95% of every single divorce case. Here, it's 100%. The reason being is they need to be sworn to, and so if the spouse won't do an inventory and appraisement and you do one, meaning your spouse is not represented, I have our clients sign a waiver stating, I'm still going to agree to this, knowing they did not do an inventory and appraisement, and that there could be outstanding issues that I could be liable for that I may not know about, and the attorneys at Turner-Monahan are not able to provide advice in regards to those because we can't get them to do an inventory and appraisement. So I think that if you do as much as you can on the front end, while the client might not think it's easy, everything that we do is trying to make sure that we're trying to cover our clients and make sure that they are covered whenever this gets finalized, especially if they're doing an agreement. I think that inventory and appraisement is something that has to be done if you're going to get into agreement, because then that can, if they didn't disclose something and you find out later, you could come back and file what's called post-divorce and division of property suit. I don't want to get too deep in the weeds on that, but that's something that you can do. Good attorneys think about the future and not just what's going on there today to try to get a case finished.
Absolutely. It's not just the drafting of an original petition, a final decree, and a waiver when you're representing somebody on an uncontested divorce. Even though, oftentimes people think about it as being that easy, there are other steps and other things that we do as experienced attorneys to make sure that our client is protected in the future, and to make sure that we've covered everything that we possibly can cover for them and taken care of them in the best possible way.